Today's topic is on division of property. Division of property is how spouses divide what they own. Today I will shed some light on the principles of law relating to matrimonial property. Traditionally, the High Court had no power to alter property rights in disputes between husband and wife. But with the introduction of the Married Persons Property Act, the High Court can make any order in relation to the property rights of husband and wife. What then is matrimonial property? Matrimonial property is property acquired by spouses during the course of their marriage or during the period of cohabitation. Matrimonial property include the matrimonial home, which is also the family home, where you and your spouse would have lived during the course of the marriage or during the period of cohabitation. It also includes vehicles and other items used by the family. Matrimonial property does not include gifts, inheritance, or property acquired after separation. Concerning division of property, spouses can make any arrangement they wish, but if the arrangement is not successful, that spouse can make an application to the High Court for a division of property. But before making the application to the High Court, you should know what are all the assets you have, and you should also know the value of each asset and your rights and obligations as it relates to the property. The Married Persons Property Act gives each spouse an entitlement to hold and equally use any property, whether or not the property is jointly or separately owned. For example, where a house is acquired during the course of the union and the parties are living together for more than 5 years and are both working, the court, in considering what is just, will award 1/2 share to the other party. If you live together for less than 5 years, the court will consider your contributions to the marriage as well as the welfare of the family. However, if you live together for more than 5 years and you did not work outside of the home, the court will award you 1/3 of the property in dispute to you. In most situations, judges will order a 50-50 division of property and will only divide property unequally in very limited circumstances. For instance, where the marriage or period of cohabitation was short, where one spouse gave up a career to look after the children while the other spouse developed a business, or where the matrimonial property is wasted by another spouse, for instance, by gambling. Just a quick recap. Property owned by either spouse going into the marriage remains the property of that individual. Property owned during the course of the marriage is matrimonial property regardless of who paid for it. Both married and cohabiting couples have rights to the matrimonial home. Debts incurred during the course of the marriage generally are debts of the couple. Property acquired after the marriage belongs to the person acquiring it. Where spouses pool their incomes and placed it into a joint account, the money in the account jointly belongs to both spouses. If property is bought in the name of your wife or husband, and you would have contributed to the improvement or buying of such property, you are entitled to a share of that property. The size of the share will depend on your contributions towards the property. This has brought us to the end of today's discourse on division of property. Audio Jungle.